BP added more than $70 billion to the U.S. economy in 2022 by making investments from coast to coast. Investments like building charging hubs for fleets of electric buses in California and starting up new infrastructure in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Content warning. This episode contains discussion of murder.
On the murder sheet, we're very fortunate to get to speak to a wide range of attorneys with experience dealing with different aspects of the law.
And one thing you learn pretty quickly when you talk to a bunch of attorneys is that often they don't agree on very much. They have very different opinions about things. And so we've always made an effort to try to bring you as many different opinions and viewpoints as we can, especially as they relate to the ongoing case against Richard Alle.
Yes, and in this episode, we'll be speaking with an attorney and an expert about the current Indiana Supreme Court case involving Richard Alle. So essentially, this is the case that may determine whether or not Allen's original attorneys, Bradley Rosie and Andrew Baldwin, come back, whether or not Judge Francis Gull leaves the case. This is a very, very important case, and so this is going to be one perspective on that. We're, of course, speaking to attorney Michael Ausbrook. He is a professor at Indiana University's Maurer School of Law, and he is the director of the Habeas project there, and he's also a board member of the Indiana Public Defender Council. Mr. Ausbrook has years of experience working habeas cases.
We were really pleased that he agreed to give us some of his insights into the Allen cases.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Richard Alle goes to the Indiana Supreme Court. A conversation with Indiana University Maurer School of Law Federal Habeas Project Director Michael Ausbrook.
Well, Michael, thank you so much for joining us today. We really appreciate you coming on the show.
Well, thanks for having me. It's quite an opportunity, and I do want to say a couple of things. One, I'm a board member of the Indiana Public Defender Council, which filed an amicus brief in this case, and I had nothing to do with the decision to do that or with the drafting of the terrific brief that Joel Schum did, who's also on the board. And I am just speaking for me. And that also goes, I also teach at the Maurer School of Law here in Bloomington, and I'm not speaking for them either. It's just little old me.
Absolutely. That's a good caveat to put in there. And we definitely appreciate your expertise. I guess before we begin, can you just tell us a bit about yourself, your background, sort of your expertise in law?
I'm primarily a habeas lawyer. There's a terrific quote I've seen it attributed to various people, but I think it fits Hemingway. So it's that critics are men who watch a battle from a high place and then come down when it's over to shoot the survivors. And so what I'm doing today is, so I'm a habeas lawyer for the most part. I've been doing that work for about 10 years together with a clinical class at the Maurer School of Law here. My students and I call them my habeas hit squad, and they are terrific. I mean, really brilliant, talented people. I really view them all as colleagues more than students, truly. So I've been doing habeas work for a while. We've had pretty good success, and I think we'll talk about that another time. But I started doing habeas work 12 years ago or so when I was just tired of the state courts. And I wanted to go see if you could spot habeas cases with a pretty good chance of winning, and then if you could go out and win them. So anyway, that's what I do. I teach habeas. Everybody makes mistakes. I've certainly made my share over the years, some fairly recently. But yeah, I think there are a few habeas lawyers around the state. I think we do most of the cases that get litigated by lawyers. I mean, there are lots of petitions by people pro se. So that's kind of my background. I graduated from law school 30 years ago, and I was contract counsel to the state PD's office for 10 years, contract counsel to the Marion County Public Defender Agency's appellate operation. And so I'm not a trial lawyer. I'm in awe of trial lawyers. What they do is the hardest thing on the planet. I couldn't do it. Certainly with state post-conviction work, there are trial-like aspects to it because you have evidentiary hearings, but those are limited to issues. You don't have facts flying, everything that you learned in discovery blowing up in your face because of a particular witness.
Well, one thing the trial lawyers in this case had to deal with was a protective order on discovery. Are those common? What sort of obligations do they place on the attorneys?
Well, I don't remember the name of the case. There was a case just litigated. There are at least two counties. I know Elkhart's one of them. That at least, and so these aren't protective orders, that when the state gives the defense discovery, they're non-disclosure agreements. It's really interesting whether those can be enforced. There's a right to discovery in Indiana. That's not true in every state. It's not true in federal prosecutions. And I don't know whether the state can restrict discovery with a non-disclosure agreement. I don't know whether protective orders on discovery are common. If you've looked at the protective order in this case, it's really kind of funny because it says these materials should not be copied for any reason. And then it goes on to say, if they're copied.
So what happened in this case, according to the affidavit, of course, is Mitch Westerman says he went into a conference room where these pictures were lying on a table, the crime scene pictures, and he took photographs of them without the knowledge of the defense attorney. And so because of that, he's been charged with conversion. So what do you think of that? Is that an appropriate charge? Is this a good case? What are your thoughts?
No, I think there's no crime here. Not all bad behavior, even really bad behavior, is criminal. Let me put it this way. I'm the pizza guy, and I'm the pizza guy, and it's my brother's house I'm delivering the pizza to. And he says, come on in, while he's going to get the money. And I step into his living room and take pictures of his family photos and then distribute them. Is that a crime? Is that conversion? No. I mean, how a judge found, we have a judge who found probable cause, and I don't get it. It's just no crime, really. I think David Hennessy said he could have a motion to dismiss ready in 20 minutes. I told him he was slow. I don't get it. And I'm not even sure, law enforcement should have been involved in investigating this. I mean, it's not a crime. Maybe they need to investigate to see if there was a crime. I don't know. I think that Andy Baldwin said that he thought he'd been the victim of a crime. I think that's in the probable cause affidavit. I just don't think that's right. But, the nice thing about getting a whole bunch of lawyers together is you're not going to get them to agree about almost anything. But I really believe there was no crime here.
Would there be in a situation like that, you mentioned not all bad behavior is criminal, right? Like something can be maybe morally wrong. We can look askance at it, but it's not necessarily that it falls to the level of the criminal justice system. I mean, like, from the perspective of something like that happening to a lawyer where somebody leaks out stuff that was in their office, is that something you've like seen before? I mean, I'd almost be worried about setting a bad precedent, but then again, it just doesn't seem to happen that often from what we can tell.
Yeah, I don't know. I've never heard of another case like that. And the other thing is, I think that, and I'm going to try and stay away from, habeas lawyers are kind of bloodless. So I'm going to try and stay away from names and just the people involved in the roles they play. There was another accusation out there that, this isn't the first incident, some discovery outline, not the discovery itself, but some discovery outline was sent to the wrong person because the email address repopulated and then another part of the complaint was that nobody was notified. The judge wasn't notified. Law enforcement wasn't notified. And it's like, why? Why would you do that? Why would you notify anybody? You would get in hold of the person I mean, why? And what's the duty to do that? I mean, you didn't release any of the actual discovery. It's your work product. Whose business is it but theirs? At least that's my take.
Yeah, no. And were you, I mean, one thing that I want to get to the bottom of this more, so I don't necessarily want to speak out of turn in terms of this. I thought it was interesting that there was some indication that perhaps the co-counsel wasn't alerted there. But I mean, it's such a brief interaction. I don't necessarily think we're getting the whole story there, but I would be curious, would that aspect of the lack of notification surprise you? Or is it just one of those things where it's like, it was a mistake moving forward? Basically we don't need to make a big deal about it.
I can see telling my co-counsel that I did that, but I can also see that I look at it. I mean, I don't know the person that it was sent to accidentally, but I can also look at it as something so unimportant, and I'm so busy I actually just forgot about it. And I just don't see what business it is of anybody's but the lawyers and the clients. I mean, if it's something damaging, you got to tell the client.
Well, of course, all this business about the leak, as we all know, ultimately led to a situation where Judge Gull, in essence, removed Baldwin and Rosie from the case. So what are your thoughts on that, just in general?
Well, let's talk for a minute about, again, sort of the bloodless thing, the geometry of the case, and which is actually, as it turns out now, the geography of the case, and then maybe some optics. So what we have here is we have couple of now fired lawyers. We have, and they're not in Carroll County. We have, maybe most importantly, I should have started with him, Rick Allen, who's not in Carroll County, not in Cass County. He's in Westville, suffering terribly by all accounts. We have a judge in Allen County. We have now 2 new public defenders from Allen County. We have a jury coming from Allen County. And then down in Indianapolis, we've got the Indiana Supreme Court. So everybody's kind of spread out, and they all have slightly different roles. And the optics of this case are just really bad. People have called it a hot mess, a dumpster fire. There's some other less flattering things they've called it. My goddaughter used to refer to something that was really hot as dirty hot. And so this is kind of a dirty hot mess. What you have here is a judge, at least as I understand the facts, and people are free to correct me, but it sounded to me from reading the transcript that the only person in Carroll County, actually, there are 2 people in Carroll County. One is the clerk, and the other is the prosecutor. That's all that's left of Carroll County. From some document, and I forget which now, it sounds like the first mention of disqualification came from the prosecutor. And then the judge said, I'm inclined to agree. The prosecutor never filed a motion to disqualify the lawyers. let's jump ahead a little bit. After the disqualification, what happens? 2 Allen County public defenders get appointed who appear in front of the judge all the time, one of whom has already commented on television about the tool mark evidence, and he didn't exactly say that, oh, that's strong evidence, but he also doesn't say it's not. And you've got a judge on her own motion who not just disqualified the lawyers, but a week before doing it, actually told them to stop working on the case with a trial date in January, which I think is so this is what, mid-October, mid-October, with a trial date 3 months out. And I think as Bob Maurer said on Defense Diaries, for the trial lawyers, that's a blink of an eye, especially for a big trial. Tell them to stop working on a case. Geez. If there are all kinds of different ways this could have been handled. If, Judge Gall thought it rose, so I used the name. If the judge had thought that what had happened rose to the level of contempt, criminal or civil, she would have had to get a special judge and gotten the prosecutor or somebody to actually file an information for contempt, and then it would have had to be tried in front of somebody else. Certainly it wasn't direct criminal contempt, it wasn't, or direct civil contempt. But as I said, I don't think there was any contempt because the lawyers did not knowingly or intentionally violate the protective order, as far as we know.
Here at the Murder Sheet, we work on the podcast and our investigative reporting full time. That means we sometimes don't have time to meticulously plan and cook delicious and nutritious meals. So, in this new year, we are eternally grateful to our sponsor, Factor.
Now's a great time to try out ready-to-eat meal delivery service Factor. Remember, when you support our great sponsors like Factor, you're supporting us and our ability to keep doing this work. So please consider visiting factormeals.com/msheet50 and use code msheet50 to get 50% off.
Factor allows you to pop your ready-made meal into the microwave. In 2 minutes flat, you'll have a hot and ready dish with minimal cleanup afterward. It's just that simple.
Also, this food is awesome. I recently dug their black bean and rice enchilada bowl with roasted zucchini, corn, and salsa verde. It tasted so fresh and flavorful.
I love that we get to skip meal prep, the grocery stores, expensive to-go orders, and elaborate cleanup. Plus, there's plenty of options for extra picky eaters like me.
We've really been thrilled with Factor, and we feel you will be too if you're striving to eat healthy and save time in 2024. It's really helped me meet my nutritional goals for the new year.
Head to factormeals.com/msheet50 and use code msheet50 to get 50% off. That's code msheet50 at factormeals.com/msheet50 to get 50% off.
So contempt would have had to mean like, I tell Kevin, hey, put this out on the internet, versus Kevin sneaking in and taking a document without my knowledge.
Yeah, I think if there's a protective order and a lawyer says, hey, go put this out on the internet, I think that would be a problem.
One thing I wanted to raise with you, we talked a little bit prior to this conversation, but just about the standard of gross negligence. What that means, is that a standard in a legal setting? What are your thoughts on that as far as, how it's being used in this situation?
It isn't the standard. And if the judge thought that the lawyers were being ineffective within the meaning of the Sixth Amendment, one thing she could have done is appointed a lawyer to consult with Mr. Allen to make sure that, and informed him of the circumstances, make sure that he was fully informed, and Mr. Allen could have decided whether he wanted to go forward with the lawyers he had. I have to say that, to drill down a little bit on facts, one of the cases we did involved the judge. It's called Lewis v. Zatecki in the Seventh Circuit. It's a 2021 case, and a public defender of hers got up at a sentencing hearing where his client, Roderick Lewis, was facing 135 years for 2 murders. And he said nothing. He introduced the client, said he'd like to say a few words. The lawyer did nothing at the sentencing hearing. And Judge Gull did nothing at the sentencing hearing except sentencing Roderick Lewis to 135 years. She did not get rid of the lawyer. And she did not get in front of, she did not get in touch with the chief public defender in Allen County and say, you really need to get somebody else in here. And I actually sort of raised this with a couple of trial judges, and I said, I didn't specify who it was, but I said, if you face this situation, what would you do? And, I'd get a hold of I'd get a new PD in there. And I'd continue the hearing if I had to. When the judge with her, and so Lewis v. Zatecki said, this is a case under United States v. Chronic where, he had a lawyer there, but it was equal to having no lawyer. And so it would have been a natural place to inquire, at least, have you prepared Mr. Lewis for this statement? The record shows that he hadn't. And this was after, by the way, the lawyer had thrown the client under the bus in closing argument, putting him in a boat with a bunch of other witnesses, just saying, these are all, including his client, really bad people. My sense is that the optics, I hate motives, and I don't know why anybody does anything. Human beings are complicated. I know that there's a thing, you may know what Occam's razor is. There's a thing called Hanlon's razor. And Hanlon's razor says, never ascribe to malice what can adequately be explained by negligence or incompetence. And, I don't know why people are doing what they're doing, but, and I know that over on Defense Diaries, there was a suggestion that this all happened to slow things down because the judge and the prosecutor weren't ready. I don't know if that's the case. It is interesting, at least, that
I'd be interested about where the source is for that.
Well, I think it was just inference. I don't think it was a source. I think it was an inference from Judge Gull. Use the name again. The judge having said that she hadn't read all of the Frank's memo and hadn't read all of Frank's memo. And I think she said hadn't looked at any of the attached exhibits. I'm not sure what the inference that the prosecutor, where the inference came from that the prosecutor wouldn't be ready. But, going back to the optics bit, you've got a judge who's, at least originally, most of the stuff is back. I can't keep track. So in the first original action challenging the treatment of the public records, I can't keep track. Maggie Smith did a terrific job along with Jesse Cook, and forget whether Kara Winicky was on that first one as well. But you have a judge who suddenly, out of nowhere, had the Frank's memo disappear. I have no idea why she did that. Somehow she thought it was inappropriate. I don't know what. I mean, lawyers talk to courts through motion, and they talk to the prosecution. Defense lawyers talk to the prosecution through motion. Nothing had been ordered sealed. The prosecutor came back with a response saying that, one line in the response was that there were things in it that were unprofessional. Well, he didn't identify anything that was unprofessional. It was actually, as I think David Hennessy's already pointed out, practically a work of, the Frank's memo was practically a work of art. You could, if they have the evidence to back it up, these are incredibly experienced trial lawyers. They're not making allegations they have no evidence for. And if they are, that's a problem.
I have a question. From you speak with other attorneys, just kind of in the community. Do you feel that it was regarded as a work of art from people you've spoken with just about this?
Yeah, I looked at it. I thought it was amazing, an amazing piece of work. I mean, and it took hours and hours and hours. And, you can argue about whether you needed to go through each. I mean, what is it? There's the section of it. It's a little bit like the history of Waterloo, and that keeps popping up in Les Miserables. But the whole step by step, how many different things whoever committed these murders would have had to do. You can TLDR, but yeah, we get the idea. It takes 81 steps to do this, and they couldn't have been done in the time. But it was thorough, it was complete, it was detailed. If the prosecution wants to prove that it's nonsense, let them have at it. But there was nothing in there that was unprofessional. They did not publish they filed as confidential the supporting documents. It was a completely professional job. And you look at the reaction. Again, it's just optics. It's not motives, but it just looks bad because that does anybody seriously think that these lawyers would have been disqualified if there had been no Frank's memo? I don't know, but it seems like it's the Frank's memo that's running this, and that the disclosures might even be an excuse. But
the judge, I think, said Frank's stuff wasn't part of it. One thing she did say was that we talked about how lawyers talk to each other and the court through filings. And one thing the judge did say was that she felt there were some basically lying by the defense attorneys in some of their motions, particularly the safekeeping motion. And so I'm curious, how is that sort of thing handled? And how should a court determine the difference between what some people might say is lying, other people might say is zealous advocacy?
Well, I don't think lying is zealous advocacy, but the fact that she believed the warden, and my understanding is that the warden didn't show up. He just filed the prosecution just filed an affidavit.
Oh, he was at the hearing. He was at the safekeeping hearing.
Okay. Well, the judge is free to believe the warden and not believe, but the fact that somebody believes somebody else and not the other side doesn't mean the other side is lying. I don't think, and the standard's probably going to be preponderance of the evidence. I mean, part of the bad optics of this too, though, are not transferring Rick Allen to Cass County when guess what? The lawyers had arranged for that to happen. The prosecutor had no objection. I mean, why didn't that happen? I don't know. It seemed like everybody who needed to be on board with that was, except for, I guess, the judge.
Well, I guess one of the major issues here, we've been talking about some of the side issues. One of the major issues is the importance of a defendant to have not only counsel, but counsel of his choice. So I wonder if you could talk about why that is important and what, in your view, some of the consequences are if a defendant does not have counsel of his choice.
Well, there's a case from 2006, I believe it is. It's United States versus Gonzalez Lopez from the United States Supreme Court. And the Sixth Amendment gives you the right to counsel of choice. And that case really says that there are only two circumstances in which you're not entitled to counsel of choice. One of those is if your lawyer's not a lawyer in the jurisdiction. And the other as if your lawyer has an actual conflict of interest. I can see, and I can see a couple of other possible situations where you might not be entitled to counsel of choice. I think one is the Lewis v. Zatecki situation where the lawyer's gotten up and said nothing. But I think you've got to, before you get rid of the lawyer, I think you have to inquire of the defendant, do you want this lawyer performing this way? And there's a case, Florida v. Nixon, it's a Ginsburg opinion, which says basically if the client either actually assents to a strategy or doesn't oppose it after it's been communicated to him or her, that's not an effective system. I mean that they ratified that strategy. So, in the Lewis v. Zatecki setting, if the judge is simply actually going off the record, even on the record, inquired about whether, any investigation has been done, mitigation investigation has been done, or actually just asked Mr. Lewis if he was satisfied with what the lawyer involved was doing, that probably would have been enough. But otherwise, the other situation in which you might not be entitled to counsel of choice is, again, if you've got something approaching, contempt. But I'm not even sure contempt gets rid of the lawyer. I don't know what you do if you have criminal contempt, direct criminal contempt. The judge sentences you, I think the limit's 6 months. The judge sentences you to 6 months in jail for the criminal contempt, and they can't. Obviously, it's hard to represent somebody from jail for criminal contempt. But I really don't see any other situations, as long as the client wants the lawyer or lawyers. Gonzalez-Lopez says it's structural error, which means you can't look at the prejudice. It would be all hypothetical. You don't know what one set of lawyers would do. And, I think Judge Gall, I keep using the name.
Right, we edit that out.
That's okay. You don't have to edit that. It's kind of funny, I think. But I've had a few run-ins with this particular judge over the years. What was I going to say? I was going to say, the Judge Gall said that she was concerned about Mr. Allen's right to a fair trial. She didn't say anything about effective assistance. She only talked about fair trial. And the due process, and Gonzalez-Lopez actually talks about this. The due process clause gives you the right to a fair trial, but the Sixth Amendment has specific provisions that implement that. The judge never found that anything any of the lawyers had done amounted to ineffective assistance. And I think without that, I don't think you can remove lawyers. That is to say, as I think in the reply in the second original action, I think it would amount to, if the lawyers remain removed, it would be a free trial. Rick Allen's been denied counsel of choice. That's structural error. The trial itself without counsel of choice is the constitutional violation. Game over. Now, you can get into a really interesting counsel of choice aspect. In this case, comes in two flavors. First, when they've been removed, and when the lawyers have been removed, they were public defenders being paid by Carroll County. And it's a slightly different question whether once a public defender's been appointed, whether you have the right to, whether Rick has the right to those lawyers once appointed. I think he does. There certainly there's I think one of the cases cited in the original action papers is a District of Columbia case. And I think once the lawyers are appointed, it's especially problematic in Indiana, where the appointments are often by judges. In fact, I mean, the judge in this case, I believe, appointed Andy Baldwin, and then I think Andy Baldwin got Mr. Rossi in as well. But you can't have what the lawyers are doing for their client, the defendant, depend on the judge's opinion of their performance. I mean, absent something that's plainly ineffective assistance on its face.
Actually, just so our listeners know and have a sense of that, what would that even look like, ineffective? You mentioned, somebody, this attorney didn't even speak up for his client, or even, threw him under the bus, as you mentioned. But what sort of things would kind of fall into that category?
Not much, actually, because as Strickland v. Washington, sort of the leading case since 1984 on ineffective assistance, says there are a wide range of ways a lawyer can represent a client and defend a client. I think you'd have to run into cases like Coy, I think it's versus Alabama, where the lawyer actually gets up and admits his client's guilt. Well, it's part of a strategy, but the client it was a death penalty case, and the idea was to admit guilt so that you go into the penalty phase, and it's actually not a terrible strategy. I think it's one that's I don't do capital work, but I think it's a fairly common thing. But apparently the client said specifically, do not do that. And if I were the judge sitting on a capital trial in light of McCoy, once the lawyer had done that, I would sort of go back in chambers with could we take a break here and go back in chambers and ask the lawyer, did your client say doing that was okay? If it is, we'll just move on, and if not, I'm going to have to declare a mistrial. But it would have to be something extreme like that. I mean, it's something it's almost unimaginable. And I have to say, in Lewis v. Zatecki, the judge might be able to assume, right? Strickland says, we assume that lawyers represent their clients competently. So, maybe it wasn't a mistake not intervening in that case, because she could have assumed that, Mr. Lewis had been prepared to make the statement. I might want to inquire, but I expect that there's a wide range, just as there's a wide range of ways to represent a client, there is a very wide range of ways to competently judge. So I'm not.
One thing I'm curious about is we talk about the Sixth Amendment right to counsel and such. And of course, the Sixth Amendment federal rights. If the Indiana Supreme Court doesn't rule on this case in favor of Allen and his attorneys, does this at some point become a federal case?
One of the reasons I've come a little ways down the hill, off the hill from the high place talk, is to express my hope that very, very sincerely held hope that it does not become a federal case. But that said, I thought it might be useful to think about the possible outcomes in the second original action in the Supreme Court. The records case is interesting, but it ultimately doesn't affect Rick Allen's trial. So what could happen? Everybody's gone. The judge is gone. The lawyers are gone. The former lawyers are gone. I don't know whether that means the current lawyers stay or whether it goes possibly to the state public defender for appointment of counsel, which is certainly something that can be done under Carroll County's public defender plan. So that's one possibility. The other possibility is judge stays, but the lawyers are gone. Third possibility is the lawyers stay and the judge is gone. And I think it unlikely that you're going to have the fourth possibility that the former lawyers come back and the judge stays. Just don't.
That would be a dirty hot mess.
That's not going to happen. So if you look down these possibilities, the one thing that there is no federal claim in the original action for removing the judge. It's just under there's no claim of, so the due process clause gives you the right to fair trial in front of an unbiased judge. But there is no claim of actual bias in the second original action as I read it. That's all under the canons of judicial conduct and sort of state law. But the counsel of choice claim is not going to go away. And if everybody's gone, doesn't work. I mean, that at least from the habeas lawyer's perspective, the only real resolution of this case that is going to be legally supportable is the judge is gone and the former lawyers are back. And it's an open question whether the former lawyers are back as public defenders or whether they're back as pro bono counsel. I don't know. And there is, if the former lawyers are not reinstated, either as public defenders or as pro bono counsel, yeah, there's a habeas case to be had. There's a statute, 28 U.S.C. 2241. It's the basic habeas statute. It says you can apply for writ of habeas corpus if you're being held in violation of the Constitution or laws of the United States. So it has to be a federal claim. And, with most habeas cases, you have to wait till the trial's over. But, and there's a case out there called Younger v. Harris that says, it's a Supreme Court case, and U.S. Supreme Court case, and it says basically that federal courts should let out of state trial. But there's a very well recognized exception to that, and that's double jeopardy claims. Now, I've seen one case that says that's the only recognized exception. And the idea is that with a double jeopardy claim, you shouldn't have to wait till the trial's over because it is the trial itself that is the constitutional violation. Normally if you have, confrontation clause violation, in other words, you're not allowed to confront the witness against you. You don't know about that. You don't know about that happening until the trial's over. But where you're given Gonzalez-Lopez and given that it's structural error to be denied counsel of choice, that you don't look at the prejudice, and the rationale applying to double jeopardy claims ought to apply for the denial of counsel of choice. And by the way, there's also, it's not just denial of counsel of choice. It's raised as counsel of choice in the original action pleadings, but there's a little thing also mentioned in Strickland called state interference with counsel. And boy, do we have state interference with counsel here. And
can you elaborate on that and what you feel is the state interference in this case?
Well, where the state is, the judgment, there's a case written by Chief Justice Rush called Becker v. State, what she says, the state is the state. Well, yeah, the judge is the state. And I think there are cases out there saying that state interference has to actually be either from the judge or because of a statute. And I think we got state interference where you tell the lawyers to stop working on a case a week before you're figuring out what's happening, and then you remove the lawyers. I think you got state interference with counsel here. We can argue it. In other words, I think a lot of people out there, all kinds of opinions about whether the removal was justified and what a terrible thing. As far as I can tell, and I think over in the defense diaries, they said sort of the same thing. This leak is a nothing burger. Nobody's got it as far as we know. It's not just at whatever. There's been no fallout from it except for to the lawyers. There's been no fallout to Rick Allen.
When you say no one's got it, what do you mean by that?
It hasn't been out. Some small handful of people may have seen whatever those pictures were that were taken in the lawyer's office. I haven't. I guess you all have, but I haven't.
Well, one image was published all over Facebook and Twitter, but bloody tree. But other than that, the worst ones, from our knowledge, have not been published on the internet, as they call it, at the very least.
Okay, well, there's one out there. I don't know that there's any indication that's been damaging to Mr. Allen's defense. Obviously, the lawyers and Mr. Allen, the former lawyers and Mr. Allen himself, don't think that there's been any particular damage, and that they want to soldier on. And so, what would happen if the lawyers might happen, and it depends on what Mr. Allen wants, and it depends on what might happen is one would have to file a habeas petition, probably in the Northern District of Indiana, asking for a preliminary injunction to stop the state trial. And, it would be more delay. And what the writ would look like would be something like either release Mr. Allen or give him back his counsel of choice. And if they don't give him back his counsel of choice, and I don't know the who would be the who is an is an interesting question. So, but if they didn't do that and they released him, then they could the state could rearrest him, and we're doing it all over again. I mean, habeas is an extremely blunt instrument. I mean, if there weren't this really clear-cut counsel of choice question, I wouldn't even be thinking about it. I mean, habeas relief is really generally for really bad violations of federal law that the state courts have failed to do anything about.
One thing I'm curious about, we've gotten some questions about this, is that the judge and the attorney general made an argument in their filings that basically, I'm simplifying, the court doesn't need to even reach the substance. There are procedural errors. These things shouldn't have been filed before the Supreme Court first. And I was just wondering if you had any insights and opinions on whether or not it was appropriate to bring this before the Supreme Court when they did.
Absolutely. I mean, I think in Mr. Allen's reply, which Mark Lehman, Kara Winicky, a couple of really brilliant lawyers did, an appeal would have taken a while, even an expedited appeal, and that's if the judge had certified the question for interlocutory appeal. I think we're out of time now for an interlocutory appeal, actually. But, we're asking for disqualification of the judge. And by the way, when removal of the lawyer's structural error, in your opinion, and by the way, the Supreme Court has exclusive jurisdiction over the regulation of lawyers, boy, it sure looks like an appeal would be inadequate, even if you could get one. And I truly think that the judge was under a duty not to remove the lawyer. Again, it comes in two stages. Even if you don't like the PD, if she could remove them as public defenders, I don't think she could remove them when they showed up again. That's just saying, well, I don't like the way you lawyer.
One thing I'm going to ask you to do, which is a super annoying question, I know, but if you have a little crystal ball there, you talked about the different outcomes that we could see here. Everyone's removed, nobody's removed, some people are removed, others aren't. But do you feel that there's a, likely outcome here as far as you see it, or is it still pretty up in the air for you?
I have, what I'm going to say is, let me preface it by saying, I haven't drunk the defense Kool-Aid, as it were. One thing about doing habeas work is, as I tell my students, you got to figure out all the ways you can lose before you can even think about winning. And I was a deputy attorney general for most of a year, 87-0 in the appeals division. So, I'm not just your old defense lawyer pushing the defense out here, but I don't see, if I were the Indiana Supreme Court, I wouldn't want to see this case again, at least not on these issues. And the only way that happens is if you get rid of the judge and reinstate. This just goes on and on if you don't reinstate the lawyers, I think. Now that's up to, that would be up to Rick Allen in the end. Maybe if Judge Gull stays and the lawyers are removed, he won't want to pursue it any further. Just get on with things. Don't know. But if I were the Indiana Supreme Court, I think given what the judge has done with the record, I think certainly wish the judge well. I know she's been ill recently. Maybe she's better. I don't know how serious it was. He has a defense. He has defense lawyers who know the case. I mean, just pragmatically, if you're the Indiana Supreme Court, you don't want to see this again. You want to get this thing going, get rid of the judge and get the lawyers back. Again, whether they come back as PDs or pro bono counsel, I don't know. I can see them saying the judge stays and the lawyers go, but I think that's a problem.
And then we breezed through all of our questions. I'm looking at the list. Is there anything we didn't ask you about or that you wanted to clarify more or that you really think people should walk away from this conversation kind of maybe thinking about?
Yeah, well, as I tell my students, criminal defense is a group effort. And if you look at, the group involved here, Maggie Smith and Jesse Cook and on the first original action, I think there were others. Kara Winnicky may have been on that. David Hennessy, Rick Allen's lawyers themselves, Andy Baldwin and Brad Rossi. Second original action, Mark Lehman and Kara Winnicky again, Joel Schum and the Indiana Public Defender Council on the amicus brief. These are all just really amazing lawyers who have stepped up and put in hours and hours and hours and hours of work without getting paid to fix something.
Awesome. Well, listen, Michael, thank you so much for your time and insight. We really appreciate you coming on, giving the habeas perspective, giving some of the perspective on, what the consequences to this pretty important event could be.
Yeah, we'll see. It's, it's why we play the games, right?
And we'll look forward to talking with you again, I think, next week.
Yeah, I'm really excited about that.
Yeah, it's going to be fun talking about the class. I look forward to it, too. Thank you for the time.
We want to thank Michael for sharing his time and insight with us. We think it was a really valuable conversation, and we just really appreciate him doing it.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.